appealing for companies to incorporate there. They have very relaxed laws, the lowest rates in terms of the filing rates that you have to pay to file for incorporation. So Delaware has really lax laws, so that's why all the corporations, not all, but a lot of them are incorporated in Delaware. And if you're able to get jurisdiction in Delaware, the courts, the judges are very amenable to companies because that's how the state makes their money. Delaware is like the place. You should Google it. You want to incorporate in Delaware.
But you would think by now they would have noticed that the fact that so many of these businesses are just incorporating there for the purpose of lower tax rates and then having their principal places somewhere else, like International Shoe in St. Louis, Missouri. You would think they've noticed by now that that's creating numerous jurisdictional issues.
They are, but as we continue to go through the cases, you'll see they've already solved it. They've solved it. So in the beginning, they were like, what do we do? They're incorporated in Delaware, principal place of business in another state. And that's fine. They have a rule for that where it doesn't put anyone at a disadvantage anymore. But even with it, you not being able to circumvent personal jurisdiction by being incorporated in Delaware, you still want to be incorporated in Delaware. They have very low state taxes on the corporation. It's fabulous. All right. Whew. Schaefer's like Pennoyer. Well, I can honestly say this is our last case. It's only Schaefer and Pennoyer, and all the other cases are like normal, like International Shoe. This is the last time. All right. So let's talk about property basis for territorial jurisdiction. So we already know a lot of this from our reading of Pennoyer, which is good. Remember that territorial jurisdiction, again, is based on property that's divided into either based on in-rem jurisdiction or quasi-in-rem jurisdiction, as we previously discussed. Remember, in-rem jurisdiction is where the property itself is the dispute, legal dispute arises from the property itself, meaning it has something to do with the property, who owns the property, where the boundary, have you all had property class yet? Mm-hmm. Yeah, so where the boundary lines or the stupid easements, I didn't like property either. Where the easements lie, whatever. I don't even remember what easements are. What are they?
It's like a driveway. You have permission to pass through the land, but not own an interest in it.
Oh, you just started property.
We're property too.
Oh, you didn't know easements?
We haven't done easements.
Well,
what kind of scheme of interest?
what had happened was we learned about movies.
Hard adverse possession.
As Professor also said, you can do property in any order. It's going to make just as much sense as any other way.
Wow, yeah, that's really hard. So we only had property for a semester. So a year is not the norm. If you Google other law schools curriculum, it's just a semester. Civ Pro is just a semester too. This is a different type of curriculum they have here. But the thought of me doing property for 2 semesters, I think I
should have went to UK.
Freaking crawling a hole.
Yeah.
Yeah, it's just, I remember what's the rule of perpetuities. I understand it now, but I hated it then, and I remember that I hated it wasn't the easements, but it was
landlord-tenant.
I love it.
Estates.
No, I like the landlord-tenant.
Estates and lands.
Estates, freehold estates and
interest.
future interest.
Actually, I was okay with that. I'll have to look in a property book and I'll be like, these things I still don't understand. I hate property. I just don't think it needs to be that difficult. I'm like, it's just
It does.
Who has time for it?
But don't tell Professor Ross. We're actually friends. We do dinner with her husband, Mark. She talks about Mark a lot, doesn't she?
No,
No,
she
no.
never talks about it.
She likes movies.
He's a professor here.
Oh, she just talks about her dog Skip or something?
No, Wizard of Oz.
Wizard of Oz.
Wizard of Oz.
So she told you she's from Kansas.
Yes.
Okay, Dorothy, I got it.
Several times.
I got it. All right. And remember, quasi-in-rem jurisdiction, the legal dispute is not about the property itself. They're just using the property in that state because they want that state to have jurisdiction over the case, so they attach the property, remember, at the onset of the suit. So I really want to stress, remember the quasi-in-rem. This is very important to you understanding Schaefer, that they attach the property at the beginning of the suit. All right, so we remember our territorial jurisdiction. Let's jump on in. So with the Schaefer case, we finally entered the 20th century, which I think is awesome. All the cases from the book until this point that discuss quasi-in-rem territorial jurisdiction were issued over 100 years ago, so this is great. They remained good law for about a century, so they had a pretty good run, and decades after International Shoe. And then 1977 Schaefer case changed the law, but it had been in effect for quite some time before this. So either, I guess Attorney Richter, since she gave the facts for the last case, do you mind telling me the facts in Schaefer? Thank you.
Yeah, so Greyhound was apparently sued in Oregon for, they had to pay some substantial damages for an antitrust suit and also a large fine for criminal contempt. So this one share, a guy who owned one share of stock, who was not a resident of Delaware, filed suit against individuals within Greyhound, so not Greyhound as a corporation, but actually officers and, holding them accountable for having to pay the damages, which I'm assuming probably damaged the company's reputation and maybe made the stock drop and and in order to try to gain jurisdiction over these individuals, he, asked for their stock to be sequestered, which meant that the defendants would not be able to sell their stock.
Okay, so great. So we're not gonna do the whole case in one term,
Okay.
but the facts are right on point and you're doing a great job. Thank you for volunteering.
Sure.
All right, so, I'm just gonna do them again, cause if we lose the facts, we're not gonna understand the case, so I'm gonna slow it down just a little bit and just highlight what, Attorney Richter said, okay? How does that sound to you, Attorney Richter? Does that make you feel like you're there, or
What do you mean, I'm sorry?
being referenced to as Attorney Richter, like, is that like,
Oh,
does it
that's
feel like
weird.
you're there, or?
No, I'm not there at all.
Just wondering. All right, so we know Heitner is a non-resident of Delaware, so we have to remember, non-resident of Delaware, files a shareholder derivative suit against Greyhound. Again, Greyhound is a Delaware corporation. So you have a non-resident defendant filing this suit against a Delaware corporation. Their principal place of business is in Arizona. All right, so many of its officers in Delaware State Court, so he filed it against Greyhound and some of its officers in state court, not federal court, upon basically alleging illegal conduct, right? Occurring in Oregon, in which Greyhound was fined. So you're a non-resident of Delaware, right? You're filing a lawsuit against Greyhound, who's a Delaware corporation, principal place of business in Arizona. And basically you're saying they did illegal conduct in the state of Oregon, all right? So Heitner alleged that the individual defendants basically violated their duties, fiduciary duties to Greyhound by causing Greyhound and its subsidiary, right? Subsidiary just means like companies that are underneath the umbrella of Greyhound. To engage in actions that resulted in the corporation being held liable for damages in a private antitrust suit, and they received a large fine. Okay, so essentially what he's saying is, you all cost the company money because you didn't do your job, and I want to hold you accountable. Like the company shouldn't have to eat the cost for the fine that you got for the illegal conduct you engaged in. So we're basically saying, these CEOs or whoever these officers are, you didn't do your due diligence. You didn't protect us. Okay, so is there any problem then with personal jurisdiction over Greyhound? Attorney Scowcroft.
Yeah. So like the request.
Meaning, can it be in Delaware? It's easy. Don't make it does Delaware have jurisdiction over Greyhound?
Yeah. No.
Okay, is there any jurisdiction problems with Greyhound? Problems having jurisdiction over Greyhound?
Yes, because like the main facility is in Arizona and like the charges were in Oregon. But I think the court says Delaware does have jurisdiction.
So what you just did, which is totally interesting, is you said
Or
no, and you said why, and then you said, but the court says yes. So the court is they have
Yeah,
the
the
final
court
say.
says-
So you said the right answer, but you gave it at the end.
yeah, the court says yes.
Okay, so we know that there's not a jurisdictional problem in Greyhound. So just as a general rule, wherever you're incorporated, that state has jurisdiction over you. Okay, that's not going to change, even through the whole semester. That's good to know. So no, Greyhound is incorporated in Delaware. It resides there. So she stated personal jurisdiction exists in Delaware. There's no problem with asserting personal jurisdiction over Greyhound. So why are we reading the case? We're reading the case because someone is challenging personal jurisdiction, and it's the individual officers. They're saying, okay, fine, you filed this lawsuit in Delaware, Greyhound Company is there, but we're non-residents of Delaware. So remember, they filed a case against the Greyhound as well as its subsidiaries and its officers. So the Greyhound Corporation, yeah, you can file a lawsuit against them in Delaware, but the officers are saying, we're not residents of Delaware. We don't have any contacts there. Like, there's a problem. So they're challenging personal jurisdiction. And so how did the plaintiff then attempt to obtain personal jurisdiction over these officers since they are non-residents of Delaware? What did they do, Attorney Scowcroft?
They were notified by mail, like direct to their last known address,
Right?
and publication by a Newcastle County newspaper.
So what you've just described to me is how they were notified about the lawsuit. You just described service of process. I want to know how they attempted to assert personal jurisdiction over the officers. You know the answer. What kind of case is this? What kind of territorial jurisdiction case is this?
Would this be quasi?
Yeah, you know it. I wish you would say it like you meant it, but yes, you haven't said anything wrong the whole class. So quasi in rem. So how did they attempt to assert personal jurisdiction? Apply the facts.
So they tried to like sequester property because they like had like some like common stuff.
Yeah. So is anybody kind of like shocked about this? So when I first took CivPro, I'm like, oh yeah, there's property in the state. They can assert jurisdiction over them, blah, blah, blah. They can attach the property. I'm thinking land when I was a student. I wasn't thinking, whoa, they're attaching stocks? Like, so if I have stocks in a company, they can attach these stocks as personal property? Like, I thought it was just real property. So I just remember for me, I was like, whoa, that's scary. So they attach their ownership of shares in Greyhound, right? This is quasi in rem, again, because the lawsuit in this case is about the shares. Remember, it's about a derivative lawsuit for violations of their fiduciary duty. And so the shares are attached at the beginning of the lawsuit so they can satisfy a judgment against the defendant in the case that the plaintiff wins. So instead of attaching real property, they attach these stocks, okay, personal property. Remember, Prenoria, again, we attached it at the beginning. Why did the plaintiff try to obtain jurisdiction in this manner instead of some other way? Well, because the basis for the jurisdiction, other bases of jurisdiction weren't available, personal jurisdiction. In rem wasn't available because, again, the dispute wasn't about the actual stocks. General jurisdiction wasn't available, which you don't have enough facts, but just know that this was the only way they could hold these officers, hopefully, under the jurisdiction of Delaware is by attaching these stocks. So could there have been general jurisdiction over the officers, again, which requires substantial context? The answer is no, because again, the officers were not residents of Delaware, so no residence jurisdiction, and clearly not enough contacts for general jurisdiction. So what about specific jurisdiction? We remember that specific jurisdiction means the cause of action or the dispute arises out of the defendant's contacts with that state. So in this case, it would be with the state of Delaware. So the reason that the plaintiff could not obtain personal jurisdiction based on specific jurisdiction is why, either Attorney Richter, why couldn't they obtain personal jurisdiction using that specific jurisdiction?
Let's see, specific jurisdiction, they need to have minimum sufficient contacts.
So did the suit arise out of the plaintiff's contacts with the state of Delaware?
No.
Exactly, no, it's in
Right, yeah,
Oregon,
so the
right?
issue was in Oregon.
Yeah.
And then, yeah, so that was the problem.
Okay, and what was the other thing you considered? What about purposeful availment? Remember that?
I guess in that context, well, Greyhound was doing,
Business, yeah, Greyhound, yeah, but what about the officers?
yeah, the officers weren't tied to, they didn't live there, right. So this was really the only, this is kind of like their stretch to try to attach them to Delaware in some way.
Yes, absolutely. Okay, so we know the first requirement of specific jurisdiction, again, is that the plaintiff's claim must arise out of the defendant's contacts with the state. This action likely did not arise out of those contacts with Delaware. Again, it arose out of the illegal conduct that was done in Oregon. Again, no purposeful availment to the benefits of Delaware, unless you count being employed by a Delaware corporation as enough, which usually that's not enough. Courts say it's not enough that you happen to be employed by a company in another state. No minimum contacts, and it's hard to make a fairness argument that it would be fair to require those officers to come to Delaware to defend themselves. When we get to another case down the line, they actually are going to give you 5 factors to determine if it's fair. So right now, we're just going to say it's not fair. There'll be 5 criteria that you use. Okay, so why sue in Delaware? Couldn't they just sue each of the directors in the states where they live? Like, won't that solve the problem, Attorney Scowcroft? Why not just sue each? You remember, whatever state you're domiciled in or a resident in, that state has jurisdiction over you. So why not just sue the directors in whatever states they were from?
I mean, I feel like that's just complicated. I mean, for like, this like company is like based, or like its headquarters.
It's not in the book. It's just a practical, why not just sue them all individually?
I mean, that's
What's
just a
the
lot of
disadvantage
time
of that?
and money.
Yeah, it's super expensive. So now I gotta get an attorney in each state where an officer is. I gotta try, and you run the possibility of getting inconsistent outcomes. One state may, you want one outcome that's binding on everybody. So it's not efficient financially or logistically to sue the directors individually in the states where they're domiciled. Remember that one of the prerequisites to quasi-in-rem jurisdiction is the presence of property, right, in the state. So were the officers' stock certificates physically located in Delaware, Attorney Richter? Were they physically there?
No.
No, they're probably located at the officer's home or a bank somewhere. So then, how was this property actually located? And it should be on the 3rd paragraph, the answer to that on page 94. So how was the property located in the forum?
It says because according to a Delaware law,
Yes.
it makes the situs of ownership of all stock in Delaware, it makes Delaware the situs for all stock of Delaware corporations.
Okay, so they've got a state statute that says if you're incorporated in Delaware, the stock, wherever they physically may be, for legal purposes, are going to be considered in the state of Delaware. Okay, so that's where that came from. There is a statute. And every state has a different statute. Delaware, again, that's their particular statute. Okay, so we know then for, again, the stock certificates would be considered located in Delaware regardless of where they are based on that statute. So what's the defendant's argument in this case? The defendant makes 2 arguments. They say, look, they weren't given notice of the attachment, so personal jurisdiction is invalid. And second, even if the attachment was valid, meaning the attachment of the stocks to assert quasi-in-rem jurisdiction, there's no personal jurisdiction over them because they still don't have minimum contact with Delaware. So that's the defendant's arguments. They're saying, look, we didn't get notice of the attachment or the suit, and even if we did, it's still not enough because we don't have minimum contacts with Delaware. So this is a big deal because think about this. Prior to Schaefer, and this is the whole crux of the case, for years, over 100 years, to use quasi-in-rem jurisdiction, all you had to do is have property in the state and attach it at the onset of the litigation. Now the defendants here are saying, don't I need minimum contacts as well? What about SHU? So now the court's like, wait a minute, should we apply minimum contacts requirement to quasi-in-rem as well? Or do we leave it like it was? Quasi-in-rem, all you need is land in the state, you attach it at the onset. Defendants are saying, no, that's not fair. We should have to have not only property in the state of Kentucky, but minimum contacts with the state of Kentucky. So that's why this is like they're trying to change the law on us again. So essentially what happens is at trial, both the trial court and the Delaware State Supreme Court reject those 2 arguments. They focus mostly on the first point and much less on the lack of personal jurisdiction point. The Delaware court basically says that for in-rem and quasi-in-rem jurisdiction, you don't need to satisfy minimum contacts. Okay, they say you don't need it for quasi-in-rem or in-rem. But the Supreme Court basically said the trial court and the Delaware Supreme Court focused on the wrong issue. Why do they have, just leave it alone? Like, do they have to come in and rock our vote? Leave it alone. You said it doesn't apply, leave it alone. But nope, Supreme Court comes in, they say, look, Delaware court system focused on the wrong issue. The court finds no personal jurisdiction over the individual officers, meaning the Supreme Court, notwithstanding the attachment of their shares in the state. So part 2 of this case poses the question, should we require minimum contacts as a part of quasi-in-rem jurisdiction? Part 3 of the case then goes on to answer that question and says that we should. You're confusing me. All right. So even though Schaefer is a quasi-in-rem case, a case about someone trying to assert personal jurisdiction by attaching property, Part 3 first examines whether an expansion of the international shoe to require minimum contacts to every type of personal jurisdiction, how that would affect in-rem jurisdiction. So essentially what the court's doing is they're saying, let's just think about this. How would it affect the different types of of jurisdiction if we apply minimum contact requirement to everything? So Justice Marshall concludes, he said, you know what, I think we're making a big deal out of nothing. I don't think it's going to affect anything, right? He says because the property itself, if that's the source of the dispute, then it's pretty hard not to have minimum contacts there. You own property there, so you're availing yourself to the benefits of the state of Kentucky. So basically, if you're a property owner, it's pretty easy to make the argument that you have minimum contacts. So I don't think it's going to make that big of a deal, he says, if we require minimum contacts, for instance, to in-rem jurisdiction. And again, in-rem is when the lawsuit is about, the dispute is about the property itself. He said also that the property itself would be a contact and would prove the defendant's purposeful availment of the state. Plus, he said the big interest in the marketability of property would likely satisfy the fairness prong, meaning the fact that most of the witnesses are in the forum state, it wouldn't be inconvenient to have you defend a suit in a state where you have property. So Justice Marshall basically concludes that requiring minimum contacts for all personal jurisdiction cases wouldn't affect the exercise of in-rem jurisdiction. Can you think of a scenario where the minimum contacts approach would change the result in an in-rem jurisdiction? And I'm going to give you a couple of examples. So again, where using minimum contacts for an in-rem action would actually change the outcome of the case. So most involve personal as opposed to real property, right? So Justice Marshall's right in that for in-rem cases, meaning they're involving land, the minimum contacts test won't change things much, right? But it might for personal property, because personal property is movable, okay? So yeah, he's right. It's not going to change it if it applies to land, but it will change the outcome if it applies to personal property, again, because it's movable. And if you can move personal property around, there's a less of a chance that you might have minimum contacts with the state where the personal property is located. So I'm going to give you a hypo to show you what I'm talking about. So say that you and I both live in the state of sunny California. Okay, we live in California, and we're having a dispute about a Rolex watch, very pricey watch. Okay, I take the watch to New Jersey, where you've never been. Okay, I take the watch to New Jersey. I file an in-rem action to quiet title the watch. Okay, in New Jersey. Under the old Pennoyer test, personal jurisdiction is proper. Why? Because the property is physically the watch in the state of New Jersey, right? So New Jersey presently has power over the property. But under the minimum contacts test, personal jurisdiction is probably absent because the defendant, meaning you, have not purposely availed yourself to New Jersey law. Like, just because I moved the property to New Jersey, whether it's a watch or a boat, that's not fair to say now you have contacts in the state of New Jersey, right? So your contact with the state of New Jersey is not enough for personal jurisdiction. So it matters if you move property around that's in dispute, whether or not you're required to show minimum contacts. It does matter. Does anybody not understand that? So again, if the property is land, yeah, you're there and you're obtaining enjoying the benefits of the state, you're paying property taxes to the state on the land. But if it's movable property, I can move that property to Idaho and then file a, hey, I'm in the boundaries of Idaho, I'm gonna go ahead and do a quick quasi in rem, and I'm gonna file a lawsuit, and you're gonna have to come to Idaho to dispute this watch. That's a problem. I don't have any contacts with Idaho, but based on the old law, doesn't matter. It's within that state's boundaries, and if the property's in that state's boundaries, that state has the power to assert jurisdiction over any property, whether it's real or personal, within their state. This is complicated.
So is there going to be a case to answer that question?
No. So just hold your question. So I'm almost there. But no, there's not. This is one of those times where we're not gonna have the real answer, unfortunately. Sorry, it's law. So what are the arguments against applying the minimum contacts to quasi in rem and in rem cases? The ones that Marshall and the rest of the majority consider but reject. So here are their arguments. They basically make three arguments. The first one is they say, look, you need quasi in rem jurisdiction without minimum contacts to stop a debtor from avoiding the debts by moving or keeping his property in a state where they lack minimum contacts, right? You don't want them evading process. So again, the first argument that Justice makes is that you need quasi in rem jurisdiction without minimum contacts to stop a debtor from avoiding his debts by moving or keeping his property in a state where he knows he lacks minimum contacts. You see how quasi in rem jurisdiction without minimum contacts avoids this. Wherever you find the debtor's property, you can sue him as of now. So the court responds to that argument and says, look, they say that argument is not a good enough justification for us to change the law and require minimum contacts. Then in a response that's edited out of your casebook, but I think it's important for your understanding, the court says you can get property anyway after you get an in personam jurisdiction judgment in another form where the debt is located because of the full faith and credit clause. They're saying even if you can't necessarily get jurisdiction in that state where the property is located, if you get a binding judgment in a state that does have personal jurisdiction, I can still go back to New Jersey or wherever, and that state has to, I'm still gonna get my money. They have to honor that binding judgment. So yeah, you may not be able to get personal jurisdiction in the state where you wanna hold a suit, but there is a state that will have personal jurisdiction, at the very least wherever they're domiciled. So they're saying it's not gonna put you at a disadvantage. It's not enough of a reason to change the law, because it's not like you can't get legal redress, right? It's not like you can't get a judgment and then take it to the state where you reside and have them enforce it. And so they said maybe they would make an exception, consider for someone that's deliberately hiding assets, like moving personal property. So maybe he's like, if we change the law, maybe we should just make an exception for people trying to take advantage of it. And they said maybe this means that you should be able to attach the property even without minimum contacts, but not that you're able to use this attachment to require the defendant to come and defend themselves. So the court's kind of like basically saying we consider the arguments, but we don't think they're compelling enough to change the law and require minimum contacts for quasi and rem. The second argument against minimum contacts for quasi and rem is on page 97 in the second paragraph. And essentially what they say is, you know what, quasi in rem and in rem cases, they're super easy to test. There's a bright line rule. It's very simple. If there's property, is there property in the forum state? Yes. And so they're like, that's much more simpler than now saying, well, do they have minimum contacts? They're like, let's not complicate things by adding this minimum contacts requirement for in rem and quasi in rem cases. Leave it like it is. It's real simple right now. It's a bright line rule. Is there property in the state? Yes. Well, you can attach that property at the onset of the lawsuit. So they're like, we don't see the need to make things more complicated. And the court's response to that is, he said it's not totally, I'm trying to figure out which justice, it was Justice Marshall. I can't remember. So Justice Marshall's response to that, meaning it's already a simple rule, leave it alone. Marshall says that even if quasi in rem jurisdiction is an easier test to apply. The cost is too high since it allows personal jurisdiction when it would be fundamentally unfair to do so. He said, in other words, simplicity is overrated. He's like, so I don't really care that it's easier test. I care about the test that's going to ensure fairness, right? The third argument against applying minimum contacts test to quasi-in rem and in rem jurisdiction cases is simply that, you know, it's history. Quasi-in rem jurisdiction has existed for over a century. So the court's saying, look, we've always done it this way historically. Why rock the boat, right? And the court responds to this on, I believe, the third paragraph on page 97. They say, yeah, fine, for some it is, but the majority of Schaefer concludes that to continue quasi-in rem jurisdiction without minimum contacts, would only support our continued acceptance that we're going to allow the process to be fundamentally unfair simply because we've always done it that way. So they're like, just because we've always done it that way, the justices are saying doesn't mean that it's the best and most fair way to do things. So all of that is to say, to answer your question, so the court in Schaefer rejects, they reject the justifications for quasi-in rem jurisdiction. Fourth paragraph, page 97. 1, 2, 3, 4. On page 97, they say, quote, and this is very important, all assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe and its progeny. So on page 97, the court says, all assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe and its progeny. Now, we don't like this statement. You know why we don't like it? Because the statement is broad, and some have interpreted this statement to mean that minimum contacts test also applies to in rem and quasi-in rem jurisdiction. I think that's a logical interpretation. It says not some, but all assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe. But others say that statement is just dicta, because the Schaefer case was about a quasi-in rem jurisdiction, and so the minimum contacts test only applies to quasi-in rem and not in rem jurisdiction. So they're saying that's not even what the case is about. So the judges are only allowed to interpret law or make law, I hate to say make law, but to make law based on that particular, what is the case about. You can't have a case on what's a good example, on breach of contract scheme and then make a ruling on a tort issue, right? You can't just, so they're saying this wasn't even an in rem case. So it's just dicta, and dicta just means sometimes the justices like to show how smart they are. They just like to give their opinion, and they're just kind of peripheralating and saying, oh, you know, I think this, even though it's not binding. So they're saying it's dicta, it's not binding, right? So that's a problem. Some people interpret that you do now need minimum contacts to apply to quasi-in rem jurisdiction. Other people say, no, that's not binding, what they said, because the case wasn't even wasn't even an in rem case to begin with. It only applies to quasi-in rem. So the court goes on in part 4 to conclude that based on this new test, there's no personal jurisdiction over the defendants and their officers. The court basically reverses the judgment of the Delaware Supreme Court. So we have Powell's concurrence here that I think is important to highlight. Basically what he says is he doesn't want to decide whether minimum contact should be applied to quasi-in rem jurisdiction cases. He says perhaps when quasi-in rem is based on the attachment of personal property versus real property, that the minimum contact test would be irrelevant. In those cases, he said we should just use that bright line rule, is their property in the state, and move on. So basically what he says is he agrees with the majority, like the stock certificates in Schaefer, and that he just doesn't want the rule to apply to real property. He says it should only apply to property that can be moved, meaning requiring the minimum contacts test. So that's what Justice Powell says. He's like, I think, yeah, we need to for quasi-in rem because that's where people can manipulate the jurisdiction process by moving property to a state where they know someone doesn't have minimum contacts. but he said, I don't think it should apply to interim cases, okay? Then we have Justice Stevens' concurrence. Justice Stevens says, look, I agree with Powell. And he says he doesn't like the breadth of the opinion. It's too broad and encompassing. He said, I only want to decide what's necessary to decide in this case. And so he's a little concerned about the notice provisions in the Delaware law. He's concerned about whether or not it's constitutionally fair or sound, if it violates due process. He states that one who purchases shares of stock on the open market can hardly be expected to know that he has thereby been subjected to defend themselves in that state wherever the stocks are legally located, not physically, but legally. And then you have Brennan, so they're all over the place, these justices. He says, look, I don't agree with Powell or Stevens. He said, I support the full application of international shoe to all assertions of personal jurisdiction, meaning that minimum context test. It should apply to every form of personal jurisdiction. And so, this crazy case, the question is, does Schaefer overrule the existing precedent that you do not need minimum contacts for quasi-in rem or in rem jurisdiction? That's really what we care about. Does it overrule how things have been done for the past 100 years? The answer is yes. So in order to exercise quasi-in rem jurisdiction, the minimum contacts plus fairness test must be must be satisfied. So again, yes, Schaefer just changed the law. They said that yes, in order to exercise quasi-in rem jurisdiction, the minimum contacts plus the fairness test must be satisfied. So this is a big deal. They keep changing the law on us, right? So as of now, this is what we know. We know to file a case in civil court, you need proper service of process, meaning notice. You need personal jurisdiction, subject matter jurisdiction, and venue. What we've learned in determining whether or not there's personal jurisdiction is you can establish personal jurisdiction by in rem jurisdiction, quasi-in rem, which now also requires you to establish minimum contacts and fairness, specific jurisdiction, and general jurisdiction. That's what we've learned thus far. Any questions? Yes.
So the minimum contact rule doesn't apply to in-rem, it's only quasi-in-rem?
Correct.
Okay.
She asked, does the minimum contacts apply to in-rem and not quasi-in-rem, and that is correct. It just applies to quasi-in-rem. But to be honest, it's kind of silly, because if you have property in the state, you're going to have minimum contacts with the state. You can make the argument with the state anyway. But technically, no. You don't have to do that analysis for exam purposes. Yes?
And as far as purposely availing, that's only for corporations doing business, like, so
No, purposeful availment is anybody.
anyone.
Yeah, so business, or if they're, I purposely avail myself to the state of Kentucky if I have a license here, or even if I don't have a license, if I own property here. I mean, anything I do to make a connection with that state is essentially going to be purposeful availment.
But you don't have to pass that test with a quasi-in-rem?
Good question. So she's asking if purposeful availment applies to quasi-in-rem. Purposeful availment now is part of that minimum contacts test. So they're now joined at the hips. Thanks to Hanson. All right. I will post the readings. It is 10:15 on the dot, and I will see you all on Monday. No, I won't. On Tuesday. MLK after the school's closed.
We're staying here, right?
We have class.
I know, right?
What's today?
No cases right now. Court's
My head is spinning. She lost me. I'm lost. I kind of got it, but I'm lost.
I read that she said that wasn't
I didn't finish it. I didn't brief. I I read the cases and everything in my book.
Yeah.
Did you put your phone?